It's clearly within the United States' power to withhold those weapons, to suspend or terminate arms and munitions transfers to Israel because Israel is not using them responsibly and is not using them in compliance with humanitarian law. There can be individual criminal liability for anybody who is complicit in the transfer of a weapon in circumstances where it's known that they would be used to violate humanitarian law. So that could also apply to United States officials if there are war crimes investigations in other countries or before the International Criminal Court. If you're fighting a terrorist group which itself is committing lots of war crimes or international crimes, that never gives a government an excuse to commit war crimes or international crimes of their own in response.
Welcome to Expert Witness, a show on international law, human rights, and public policy. Our guest today is Professor Ben Saul, the UN Special Rapporteur on counter-terrorism and human rights and the Challis Chair of International Law at the University of Sydney. Following the ceasefire between Israel and Hamas on 19 January, Trump shockingly announced that he plans to take over the Gaza Strip, transfer its Palestinian population to other countries, and rebuild the territory into the Riviera of the Middle East. Professor Saul joins us from Sydney to discuss the legal implication of Trump's plan, which has been criticized as a call for the ethnic cleansing of the Palestinian population there and a grave violation of international law. Professor Ben Saul, welcome to the show.
Good to be with you.
Thank you very much. First, could you begin by explaining your mandate as a UN Special Rapporteur and what your role entails, please?
Of course, I'm the UN Special Rapporteur on human rights and counter-terrorism, and my job is to monitor the compliance of all countries, all 193 countries, with human rights when they counter terrorism. So that includes in their laws, policing, intelligence and security, military operations, border security. So we look across the board. We also monitor the United Nations counterterrorism architecture. So about 46 UN agencies are involved in counterterrorism in some way. And we, of course, want to make sure that the Security Council, the General Assembly, and all the parts of the UN system are also respecting human rights. We bring individual cases to governments where we identify violations of human rights. We comment on new legislation which could infringe rights. We present annual reports to the General Assembly and Human Rights Council about contemporary human rights challenges in our areas. And we undertake country visits at the invitation of countries and make constructive recommendations to improve human rights compliance.
And as part of your mandate, you've also been quite outspoken about the international law violations in Gaza and elsewhere by the State of Israel. Lately, of course, you've also written and spoken extensively on the bizarre suggestion by President Donald Trump that he plans to take over Gaza and turn it into a Riviera for the world's people or anybody other than its Palestinian residents. As a UN Special Rapporteur and as an international law professor and scholar, could you please give us a legal assessment of such plan and what sort of criminal liability could result from this plan should it go ahead?
So the US president's suggestion that the United States should take over and own Gaza would really be a violation of some of the most fundamental rules of international law since the new legal order was founded in 1945. After the Second World War, the United Nations Charter was agreed by all countries at the time, including the United States, which played a very important role in its drafting, precisely to prevent war from recurring again. So one of the most fundamental rules is the ban on the use of military force aggressively for any purpose, but also including for the purpose of illegally annexing some foreign territory to try to somehow assert your own sovereignty by aggressive force. In a kind of colonialism of the kind we saw was all too common before 1945. So it's prohibited to use military force to take territory, to colonize it, to claim to annex it. And of course, it's also illegal to try to depopulate foreign territory by forcibly deporting or expelling its population. And in fact,
Mhm.
under the Geneva Conventions of 1949, what we call international humanitarian law, it's a war crime
Mhm.
for anybody to forcibly deport the population, any part of the population of an occupied territory. So these are really some of the most basic rules of international law, and breaking them, of course, is bigger than Gaza because it sends a signal to the rest of the world, to other authoritarian governments and dictators in other countries, that they
Mhm.
have a right to take territory that they want and to embark on their own colonial activities.
And what could be the legal consequences for that should the plan go ahead? For example, do you think it would be plausible for the ICC, for example, to issue an arrest warrant for President Trump or anybody like senior officials behind such a plan?
Certainly, there would be the possibility of war crimes investigations and charges in a number of places. So, firstly, all countries have universal jurisdiction over war
Mm-hmm.
crimes wherever they occur. Even if your own citizens are not involved, even if it takes place in a foreign country. The whole point of universal jurisdiction over international crimes
Yeah.
is that there should not be impunity anywhere, and that the
Mm-hmm.
perpetrators should be tracked down and held accountable. So other countries could open investigations potentially and pursue responsible American officials. But in addition, of course, the International Criminal Court has jurisdiction because Palestine is a state party to the Rome Statute of the International Criminal Court. That the judges of the court have accepted that they have jurisdiction over the situation in Palestine. And so, although the United States, of course, is not part of the International Criminal Court, that doesn't matter, legally speaking, if international crimes are committed on the territory of a state that is a party, that being Palestine. Now, that would bring into play the obligation of almost 130 other countries who are parties to the Rome Statute of the International Criminal Court and who themselves have
Mm-hmm.
obligations to cooperate with the court to arrest people who are wanted by the court for prosecution.
Professor Saul, you are the UN Special Rapporteur on counter-terrorism and human rights, as well as the Challis Chair of International Law at the University of Sydney. The allegation of fighting terrorism has been central to Israel's war on Gaza and Lebanon and elsewhere. Is fighting terrorism a justification for attacks that eventually kill civilians under international law and international humanitarian law? Could you please walk us through the legal implications of that and your legal analysis, please?
So, under international law, every country must respect the rules of international law relevant when countering terrorism. That includes the international prohibition on the use of force, it includes international humanitarian law, and also international human rights law. So there are no exceptions, even when fighting terrorism or fighting a war for national survival in a traditional interstate conflict. Those rules must always be respected. They also have to be respected even if the other side does not respect them. So if you're fighting a terrorist group which itself is committing lots of war crimes or international crimes, that never gives a government an excuse to commit war crimes or international crimes of their own in response. Now, when there's an armed conflict, international humanitarian law contains a series of rules to regulate the fighting. That means allowing both sides to fight militarily while also respecting fundamental constraints in order to protect civilians and prisoners, to ensure that humanitarian relief is provided to civilian populations who are caught up amongst the fighting, to ensure that hospitals and medical professionals are protected, and to ensure that even prisoners of war or prisoners who were once fighters are treated with respect and dignity and are not tortured or mistreated or denied food or medical care in detention. Now, of course, during war fighting, some civilians will inevitably be killed. That can be lawful in certain circumstances. But the key rule here is what we call the rule of proportionality, which means that it is illegal to launch a military strike if the civilian casualties anticipated from that strike would be excessive relative to the military advantage anticipated. In other words, you cannot cause disproportionate civilian casualties when undertaking an attack. Further rules to protect civilians require that the parties fighting must take what we call adequate precautions, all feasible precautions, to ensure that they verify the target is military and not civilian, to also verify that the civilian casualties would not be excessive. So if you can do things like attack at a different time or attack in a different way by, for example, using a less powerful weapon or a weapon which is more precise or more targeted, and if doing that would protect more civilians, then those are things you should do in conducting your war fighting.
And speaking of weapons, the US and Germany provide nearly 99% of arms and munitions to Israel, with, of course, the US being the biggest supplier. What are the legal consequences of that under international law?
So there are a few consequences. Under humanitarian law, there's an obligation on all countries to ensure respect for humanitarian law by other countries fighting in armed conflict. That means if it's within your power to influence the conduct of another country, then you have to take all feasible steps to ensure that you promote compliance with humanitarian law by that other country. Now, if you're exporting weapons to a country like Israel, and you know that Israel is routinely violating humanitarian law when using those weapons. So, for example, if Israel uses large, high explosive bombs supplied by the United States in densely populated urban areas where we know there are civilians in the area, then it's very hard to reconcile the use of those weapons with complying with humanitarian law. So in those circumstances, it's clearly within the United States' power to withhold those weapons, to suspend or terminate arms and munitions transfers to Israel because Israel is not using them responsibly and is not using them in compliance with humanitarian law. For other countries who are parties to the arms trade treaty, like many European countries, there are then additional obligations under that treaty to not to export weapons if they would be used to violate humanitarian law. And even if you are not certain that they would be used to violate the law, to commit war crimes, then there's still an obligation not to transfer those weapons if there's an overriding risk that they would be used to violate humanitarian law. So there are a number of protective provisions preventing the export of weapons precisely to prevent violations of humanitarian law. I'd also mention under international criminal law, there can be individual criminal liability for anybody who is complicit in the transfer of a weapon in circumstances where it's known that they would be used to violate humanitarian law. So that would also apply to United States officials if there are war crimes investigations in other countries or before the International Criminal Court.
And also in the UK, we know that British made spare parts continue to sustain Israel's F 35 fleet. Could there also be criminal liability for UK leaders if they do not act to prevent such transfers?
So arms transfers, the law on arms transfers applies not only to complete weapons or munitions which have already been built, but also to the export of parts and components. So in the F-35 fighter jet example, many countries are contributing parts to the construction of those jets, which are then assembled and exported to countries like Israel. So there's an obligation on every
Mm,
country, that industrial chain building those weapon systems, to ensure that they do respect the constraints on arms transfers, to ensure humanitarian law is not violated. So again, if there's evidence that F-35 fighter jets are being involved in indiscriminate bombings, which cause excessive civilian casualties, then certainly
mm.
that's also something which could attract individual criminal responsibility as well.
And Professor Saul, concerning the latest Unrwa ban by Israel, could you also unpack the legality of that?
So the Israeli parliament adopted two laws recently which ban Unrwa from undertaking any activities within Israel. Israel, of course, claims that East Jerusalem is part of Israel, and Unrwa's headquarters are based in East Jerusalem. So that ban essentially shuts down the nerve center or the headquarters of Unrwa for all of its operations in the Palestinian occupied territories. In addition, Israel passed a law banning Israeli officials from having any contact with Unrwa. And so that, of course, prevents cooperation on issuing visas,
Mm,
on customs controls for the movement of humanitarian goods and relief into Palestine. So essentially, it's an effort to really close down the capacity of Unrwa to operate. The problem, I mean, there are lots of problems with that. Foremost, of course, it's that UNRWA has a mandate from the United Nations General Assembly. States in the region are required to cooperate with UNRWA. It's not just some kind of free choice of Israel whether to continue to cooperate or not. It's an obligation as a member of the United Nations. Under the UN Charter, there is an obligation to cooperate with the mandate of UNRWA. There's also an obligation to respect the international immunities and privileges of UNRWA as part of an international organization. That means
mm,
not seizing its property, like its headquarters premises in East Jerusalem, not interfering with its staff or the movement of its vehicles, its warehouses, etc. And so these are all obligations that are being violated. Of course, the General Assembly, the Security Council, the Secretary General have all said, as we have in United Nations Special Human Rights Special Procedures, that the role of UNRWA is absolutely indispensable to the provision of not only humanitarian relief in Gaza, but also all kinds of other essential services in the Palestinian
mm,
territories more generally,
mm,
including education, healthcare, and other basic services. So there is no other actor who can fill the gap, who can somehow substitute for the role that UNRWA plays, also in coordinating a much larger group of humanitarian actors, including other UN actors on the ground. And so the fact that this is being done in the middle of an acute humanitarian crisis, when many people in Gaza are facing extremely high levels of hunger and malnutrition, where most of the buildings and public infrastructure have been damaged or destroyed in Gaza. Now is
mm.
not the time to play around with trying to replace UNRWA with something else. And by the way, Israel has not put in place any kinds of mechanisms or alternatives which could fill the gap that UNRWA provides currently.
Professor Saul, concerning the US aid 90-day freeze by the administration of President Donald Trump, what's your assessment of that, legally speaking?
So certainly, foreign aid by a country like the United States is absolutely essential to sustaining all kinds of humanitarian relief and human rights and development activities worldwide. The United States is really the largest donor in the aid and development areas. And so shutting down large parts of its programming virtually overnight with almost no notice to anybody, without anybody else having the capacity to fill that gap, of course, has an incredibly detrimental impact on all of the incredibly valuable activities that USAID has been supporting over many, many years. That includes human rights protection activities, as well as development and humanitarian relief activities. It's also a time when many other countries are not themselves living up to their commitments to adequately fund development and humanitarian relief activities. In fact, quite a few donors around the world have been reducing their funding towards the international system in many areas in recent years. So this has incredibly negative impacts on human rights activists in countries where very authoritarian regimes are currently repressing human rights. It has real-world consequences for the lives of children or people who are malnourished and dependent on US food aid, or who are receiving life-sustaining medical care from USAID-funded projects. But quite apart from the human rights and humanitarian impacts, it's also an incredibly unwise thing to do from a security standpoint as well, because we know that some of the conditions conducive to violent extremism and terrorism, some of the root causes of why people feel aggrieved and resort to violence in some countries, is precisely because they are economically marginalized. Their own state hasn't been providing adequate essential services, livelihood opportunities, etc. And right back in 1945, in the United Nations Charter, the link between human prosperity and opportunity and ensuring peace and stability was well recognized. And that's why we had such an effort after the Second World War to rebuild countries that had been shattered by the war, to try to make them prosperous, so that we don't fall into the trap of political violence, which had led to the Second World War.
Professor Saul, to conclude, are we nearing the end of international law as we know it, historically speaking, because of all these incidents of non-compliance by leaders of Western states?
I certainly think we're facing tough times and real challenges to not just particular international rules, but to the international legal order as a whole. I mean, to put it in perspective, of course, international law has always been hostage to political power. I mean, international law is made by the governments that the law is trying to constrain and civilize and regulate. There is no international police force. The most central institution we have is the UN Security Council, but of course, the great powers who won the Second World War have a veto, and so have always been able to prevent the enforcement of international law against themselves. And so unless you have a kind of series of relatively benign, powerful countries interested in the global enforcement of international law, then it will always be difficult to always enforce it. Selectivity in the enforcement of international law for political reasons, double standards. I mean, we know these have always been features of the law. I do think the present moment is particularly dangerous because the United States, for all of its faults and for all of the times itself it has violated international law, it is a complex country, and other parts of the US government have been supporting and funding, as the major funder, the global human rights system, the global humanitarian relief system, and with the new kind of America First, Trumpian isolationism, if America walks away from that, there's no single country or group of countries is obviously placed to replace it. I mean, nobody has the same kinds of capacities or political will to do it. And that does leave a void in the international system. It also enables space for other states who aren't so interested in human rights to become more powerful in the multilateral scene. And we've already seen that in recent weeks with extraordinary scenes of the United States voting with Russia on a resolution on Ukraine, which utterly abandons some of the most basic rules of international law that at least previously the US said it believed in, even if it didn't always act in favor of them.
Professor Saul, thank you so much for your time today. I know you're extremely busy as a UN expert and a law professor as well, so I appreciate your time.
Thanks so much for having me, and see you later.
You're welcome.